This story comes out of Jackson, Mississippi. And I gotta commend this judge. I had to go find him and see who he was because, well, you already know the story. You got a judge doing something like this, trying to end qualified immunity. And I just wanted to see how his face looked. Yeah, I've kind of expected it would be a brother because that's just out of the ordinary for someone else. Let me try to watch what I say here because YouTube kind of funny with their guidelines. Like the story I did about the North Carolina mask ban. It was actually a story showing how they were going to use that mask legislation to target certain individuals while letting secret societies, for example, like the Ku Klux Klan, to continue wearing masks during their public functions. And I got a copyright strike, not a copyright strike, but a strike for hate speech. And I know I could have easily beat it because there's no hate speech in the video at all. But when I was reviewing it, I accidentally hit submit appeal without actually inputting my appeal. So I've beaten many of these strikes numerous occasions. Basically, it seems to me that if you're creating content exposing, race issues throughout this country, that your channel will be targeted. Black community, we know all too well how these social media sites get down. They're not gonna promote our videos because our videos don't coincide with their ideologies. That ideology of white supremacy. But yeah, I had to go find. Excuse me. I had to go see what this judge looked like. Something told me he probably was a brother or a sister, just for the fact that they doing the right thing. That's you really shouldn't praise someone for doing what is expected of them. But I gotta give them a high five for this because it's needed. I always say, how do you deter these officers from committing such acts? Well, one would be a swift reply to their actions, whether it's jail time or, someone that's not in the legal system. Let me just put it that way, if you know what I mean. But that's what I believe that it would stop if you start arresting these people. Now, this case right here, I'm about to play and let you listen to. This female officer definitely needs jail time for what she did. She coerced a witness to say that this was the man that committed capital murder, which it wasn't. It was the person they used was a paid jail informant, and what they do is they give you counts. It's either put something on your books or shorten your sentence. They give you little rewards to say this was the person that did it when it actually wasn't. Thankfully, this person came back later and recanted his statement. This man spent 2 years in prison for something he didn't do, and he's suing this officer, which he should, and he's saying that qualified immunity seems illegal, and it is. No one else has qualified immunity. These police officers commit these acts against people, and they are protected. You can't come back around and sue them, and I think that's bullshit. You know, no one has that type of protection, whether it be doctors or lawyers. A doctor, they get you for malpractice. Lawyers, they your lawyer, they remove you so you can't practice law in certain states. So, and it just goes on and on. Who has protection like that? Me or you? We go out and whether you meant to do it or not, if it was an accident, you still open up for a lawsuit. So I believe the police shouldn't have this protection either. Now, this article was saying that if you remove their qualified immunity, what will happen is you will have less people that want to join law enforcement. And I do believe that. But what you do is in certain cases like this, where it was shown that the officer acted outside of the law, you strip them from their qualified immunity, most definitely, and that will stop all of that foolishness they doing out here. But let's get into the story, and then I'll give my commentary at the end.
Mississippi judge rules qualified immunity has no basis in law in cause brought by wrongfully arrested black man paves way for civil rights justice. May 28, 2024, a judge in the U.S. District Court for the Southern District of Mississippi recently denied qualified immunity to a detective who had falsely accused a Mississippi man of capital murder, and in doing so also agreed with the plaintiff that qualified immunity itself is unlawful. The decision could reshape the landscape of civil rights litigation. The ruling, handed down on May 20th, could turn into a significant blow to the controversial legal doctrine that has often shielded law enforcement officers from lawsuits. The case centers on Desmond Green, who was wrongfully accused and arrested based on the affidavit of a lying, drug-impaired jailhouse informant solicited by Jackson Police Detective Jacqueline Thomas. The detective had guided the informant to identify Mr. Green from a photo lineup, according to the 62-page order issued by District Judge Carlton W. Reeves, United States District Court for the Southern District of Mississippi. Photo, missp.uscourts.gov, that led to Green spending nearly 2 years incarcerated in the Hinds County Detention Center, a facility known for its violence, rodent infestation, and moldy food. According to the order, at the time, Green lived in constant fear, often sleeping on the bare floor amidst constant yelling, fighting, and threats. Reeves wrote, after the informant recanted the testimony, the charges against Green were dropped, seeking justice for his wrongful prosecution and the harsh conditions of his confinement. Green filed a federal civil rights lawsuit against the detective, the city of Jackson, and Hinds County, which operates the detention center. Green filed this lawsuit to seek justice for those two wrongs: his prosecution and conditions of confinement. He has sued the detective who obtained the warrant against him, her employer, the city of Jackson, Mississippi, and the operator of the Hinds County Detention Center, Hinds County, Mississippi. Reeves wrote in the ruling, Green is now on the precipice of being wronged a third time, not by a rogue officer or jailer, but by the law itself, because the detective says the legal doctrine of qualified immunity requires the court to dismiss Green's claims against her. The ruling continued. Until this point, the decision was shaping up as a more or less standard denial of the government's claim that it was entitled to qualified immunity in the case. But what Reeves wrote next struck at the heart of the legal doctrine itself. Green is no. Most plaintiffs in this situation argue that the officer that wronged them isn't entitled to qualified immunity. Green does that. Unlike others, though, he has taken the next step and argued that qualified immunity itself is unlawful. He joins lawyers, professors, judges, and even Supreme Court justices who have called for the doctrine's reevaluation, if not its abolition. The court agrees with these calls for change. Congress's intent to protect citizens from government abuse cannot be overridden by judges who think they know better. As a doctrine that defies this basic principle, qualified immunity is an unconstitutional error. It is past time for the judiciary to correct this mistake. The doctrine of qualified immunity is a legal principle that protects government actors from being sued for their actions unless those actions have previously been ruled unconstitutional. The Supreme Court first carved out this protection in 1967 with its ruling in Pearson v. Ray A. Case brought by a group of ministers who claimed their civil rights were violated by authorities in Jackson, Mississippi. Qualified immunity was invented by the Supreme Court in 1967, Reeves wrote. In plain English, it means persons wronged by government agents cannot sue those agents unless the Supreme Court previously found substantially the same acts to be unconstitutional. In the Pearson case, the ministers argued that their 1961 wrongful arrests and imprisonment for simply entering a bus station was a violation of the 1871 Ku Klux Klan Act, a federal law enacted specifically to give black citizens protection against police who would collude with white supremacists to violate the civil rights of African Americans. The High Court ruled in Pearson v. Ray that the Jackson police who arrested the clergyman for breach of peace were not liable because officers reasonably believed their actions were constitutional. Reeves, describing the twisted irony of the Pearson ruling, wrote, "The justices took a law meant to protect freed people exercising their federal rights in southern states after the Civil War, then flipped its meaning in creating qualified immunity. The High Court 100 years after the war ended. Southern trees bear strange fruit, indeed, the 60-year-old president." Joe Biden appointee, in concluding that Thomas was not entitled to qualified immunity, as her actions violated clearly established constitutional law, also traced qualified immunities its evolution into what Justice Sonia Sotomayor has described as an absolute shield for police officers accused of excessive force, according to the Equal Justice Initiative. In a powerful conclusion, Reeves declared that qualified immunity has no basis in law and described it as an extra-constitutional affront to other cherished values of our democracy. The ruling, in the unlikely event it is upheld on appeal, could lead to more accountability of law enforcement officers, an issue backed by several civil rights advocates. Clark Neely, Senior Vice President for Legal Studies at the Cato Institute, describing Reeves' ruling for Newsweek, said, "Qualified immunity has become an extremely controversial legal issue because it creates this defense out of whole cloth. Courts are not really supposed to make policy. They're supposed to rule on existing laws. Meanwhile, qualified immunity has sparked a wide range of reactions and debates, with supporters arguing that it protects public officials from constant lawsuits. According to legal experts, they believe that without this legal shield, those officials could be overwhelmed by costly lawsuits, which could deter people from joining these professions. On the other hand, critics argue that qualified immunity has allowed law enforcement officers to violate citizens' rights, especially those of disenfranchised individuals, without facing any repercussions. One of the biggest problems with qualified immunity is you cannot find it written into any federal law or statute, attorneys Melvin Hall and Jeff Bell wrote in an op-ed published in Newsweek.
Yeah, shout out to this judge for doing the right thing. You hear the people opposed to this saying that the court shouldn't make law. Well, if the law is wrong, that's where it should start, in the court. You know, we all know that the courtrooms can't make legislation, but they definitely can play a part in creating legislation, the right legislation. This, like I say, these type of incidents are just common. You hear it a lot. But I hope this brother succeeds with his efforts to sue this officer. If they don't want to give her jail time, which she definitely needs for acting outside of the law, coercing witness statements, well, not even a witness, you're talking about a jailhouse informant, you coercing them into making statements that was the person, and it actually wasn't the person. So this man spent 2 years in jail for something he didn't do. So I'm gonna follow with this, and if I have anything new comes out, I would definitely upload it, see what's going on. But it seems like the judge is not well liked at the moment for coming out with this, and that's to be expected, because they want to keep the same thing that they always had. This was a very interesting story, because I've learned where the qualified immunity came from. So they created this to protect the police officers Back in 1967, I think the story was saying, for the black preachers that were wrongfully arrested. So they concocted this law in order to protect the police from getting sued. So, yeah, I'm going to try to keep up with this story, and anything new comes of it, I will definitely upload it. Lead us here, and let me hear what you got to say in the comments, and I'll see you on the next one.